Welcome to the Compliance 911 Show, a no-nonsense podcast discussing hot topics for today's busy compliance professional. It's everything you wanted to know about regulatory compliance, but we're afraid to ask. And now, here are your hosts, Dean Stockford of M&M Consulting and Len Suzio of GeoData Vision.
Welcome to today's podcast, which is part 2 of a 2-part series in which we're delving further into the Executive Order 14281, Restoring Equality of Opportunity and Meritocracy, issued on April 23rd of this year, 2025, which seeks to limit the use of disparate impact fair lending legal theory by federal agencies and even state authorities. And backed by popular acclaim, we have attorney Lori Sommerfield. Lori is a partner in the law firm of Troutman Pepper Locke in the firm's Consumer Financial Practices Group. Lori has more than 25 years of experience in federal government, in-house, and private settings. She works with clients in all aspects of regulatory compliance. I personally have worked with Lori in recent years as she defended clients that were threatened with redlining referrals. I can tell you, she was 100% successful in persuading regulators not to proceed. A year ago, we had Lori as a guest to discuss redlining and the Combating Redlining Initiative. We received such great feedback from the audience about that podcast. We said, why argue with success? So Dean and I decided it would be great to have the superstar back for another podcast. So welcome to today's second part of a 2-part series on President Trump's Executive Order 14281. Lori, we're happy to have you back. Thank you for graciously being a guest on our show again. Welcome to part 2 of this 2-part series.
Oh, thank you so much, Len and Dean. It's a pleasure to be with you both again.
Let me jump right in. The executive order issued by the president as the head of the executive branch of the federal government seeks to dismantle the legal theory of disparate impact at both the federal and state levels. But didn't the U.S. Supreme Court uphold the use of that theory in the context of Fair Housing Act in the Inclusive Communities case in 2015? Can you tell me more about that? And has the Supreme Court also addressed whether disparate impact is cognizable under the Equal Credit Opportunity Act?
Yes, Dean. The Inclusive Communities case, which was decided by the U.S. Supreme Court back in 2015, held that disparate impact is cognizable under the Fair Housing Act, and that case still stands as good law today. However, the Supreme Court has never definitively determined whether disparate impact claims can be brought under ECOA. Nonetheless, the federal banking agencies have held the view since 1977 that disparate impact is cognizable under ECOA. And then they subsequently upheld that in the interagency guidance on fair lending that was issued in 1994. And by the way, I referenced 1977 as kind of the key year when that began, because that's when Regulation B, which implements ECOA, was amended to include the statement about the effects test, which is essentially disparate impact language. But personally, I don't think the disparate impact was actually contemplated by ECOA when Congress enacted it. So the effects test standard likely wouldn't stand up to scrutiny by the Supreme Court, in my opinion.
That's interesting. That's very interesting. That's why we have you here, Lori. Your legal mind is ahead of everybody on this. So let's let's turn next to discussing state fair lending enforcement activity. Now, in terms of the fair lending enforcement void that will now be left at the federal level, do you think state authorities will be stepping up enforcement of their fair lending laws, almost all of which recognize the disparate impact theory?
Absolutely, Len. I mean, there's no question that state regulatory agencies and state AGs will be increasing their efforts to enforce state fair lending laws. We know that certain state authorities, like the New York Department of Financial Services and attorneys generals from certain states like Pennsylvania and New Jersey, are interested in using the disparate impact theory based on their prior enforcement activity. So there's no reason to believe that those and other state authorities won't continue to do so. This obviously poses risk for financial institutions, even if enforcement of the federal fair lending laws using the disparate impact theory isn't being used at the federal level any longer.
So, what about private litigation asserting use of disparate impact theory? Is that still at risk for financial institutions?
Absolutely, Dean. Private litigation is also a significant risk for financial institutions, particularly for discrimination lawsuits that are brought by individual plaintiffs, which can turn into either class or mass actions, and for consumer or fair housing advocates that we expect to bring these types of lawsuits. And by the way, both the COA and the Fair Housing Act allow for a private right of action, and several state fair lending laws do too. And I can think off the top of my head of at least 5 states that have a private right of action, including New York and California, Illinois, as you would expect, as well as Colorado and Minnesota.
Wow. So a lot of bankers might be thinking, oh, we're getting a break here from the Trump administration, but be careful what you wish for. It sounds like it could get to be even more confusing with state regulators taking a more aggressive stance on this. And since every state has its own laws, it can get pretty complicated, can it, Lori?
Well, it can for lenders that do business on a multi state or a national basis. Yes. I mean, because despite these federal changes, disparate impact claims remain viable through state attorneys general, state banking agencies, as well as private litigants.
Hmm. So do you think that's kind of an area that for lawyers is going to be a new field? Because again, it's been the federal government that's been pretty much asserting disparate impact theory and using it in anti-discrimination cases. I assume that's not only going to present a challenge to bankers themselves, it's going to present a challenge to attorneys like yourself, because you got 50 different states, right? And potentially 50 different approaches. It could get to be pretty complex from a legal point of view too, right?
Well, not necessarily. I mean, every state has, the ability to enforce its own fair lending law, and many states have relied on the disparate impact theory in the past. Primarily the key states that I've talked about, California, New York, Illinois. So I don't think it's any different. We're just witnessing a shift from federal government enforcement, primarily using the disparate impact legal theory, to now the states doing so, as well as private litigants.
So if risk still exists for lenders based on either state authorities or private litigants asserting discrimination claims based on disparate impact theory, what can lenders do from a practical point of view to mitigate those risks, Lori?
Well, then, our advice to clients is to keep their fair lending risk management programs intact, despite what's going on at the federal level, because of this risk we were just talking about. You have the risk of state investigations or enforcement actions, as well as the risk of private litigation. That means financial institutions should continue to review their policies, procedures, and practices for any potential disparate impact risk. They should conduct fair lending monitoring and testing to ensure that those results don't reveal disparate impact. And they should also make sure that they've got a strong business justification for any policies, procedures, and practices that could be controversial or raise disparate impact risk. And also make sure that if there are any less discriminatory alternatives, that they use them, or that they've ruled out that any less discriminatory alternatives exist. And that way, they'd be in a better position to defend against any claims of disparate impact from either state authority or a private litigant. And I also should know that it's important to document the rationale behind policies and practices and perform that less discriminatory alternative testing and document that in order to form a strong and proactive defense. Those are all ways in which lenders and financial institutions can mitigate these risks.
Great advice, for sure.
Yeah, I was just going to say, we always tell our clients, document, document, document. You can never do too much documentation. Just to assume that a regulator is going to understand your rationale is not a good approach. You've got to lay it out for them and make sure it's in writing. That's the best defense.
Yeah.
Agreed.
And I can see now a lot of bankers are sitting back, probably jumping for joy about this executive order. While at the same time, I think they might want to be, caution in the air, like with anything else, is what I always say. But despite the executive order directives, do you think that the federal agencies could return to using that disparate impact theory during, say, a future administration, Democratic administration, if they come back in or repeal or roll back or adopt a totally different stance?
Yes, Dean. And I think that financial institutions should operate under the assumption that the use of the disparate impact legal theory will return again. President Trump can't permanently prevent federal agencies from using the disparate impact theory because his executive order is only in place while he remains in power, as we discussed earlier in this podcast. And after once and future regulators like the CFPB are back in power under a future Democratic administration, that order would likely be immediately revoked by the Democratic president at that time. It's also important to bear in mind, as Lynn previously mentioned in our podcast in part 1, that the statute of limitations under a COA is 5 years. So if a Democrat became president as a result of the next election, a federal regulator could conduct a 5-year look back at activities that occurred under the Trump administration and potentially initiate an investigation using the disparate impact legal theory. So that's why we advise our clients to keep on keeping on with their fair lending risk management program so that they're in a solid position to refute any disparate impact claims in the future. So, while the Trump administration has provided some temporary relief to the banking and financial services industry from use of the disparate impact theory by federal regulators for now, enjoy it while it lasts.
As the world turns, the pendulum swings back and back and forth.
And the pendulum swing is getting more and more wild with each administration, as we've seen. It used to be a predictable pendulum swing, but now I think we're beginning to really see extreme regulatory whipsawing.
I've developed a term, I call it regulatory ping pong, is what's going on right now, and it's getting more. The pace is getting faster, back and forth. I mean, the radical change that occurred from the Obama administration to the Trump administration, then back to the Biden administration, now back to the Trump administration. I can't recall in my 50 years or so of experience any more radical changes over such a short period of time from one administration to the next. You've had many years of this, Lori. Have you seen anything like this before at this pace and this extreme?
No. And Lynn, I've been practicing law for over 25 years, and I've never seen the pendulum swing be as extreme as it is during the past 4 administrations. The Trump 1.0 administration was actually more moderate in approach, but I think as a reaction to the Biden administration, we're seeing Trump 2.0 take more aggressive positions to shut down use of the disparate impact theory, for example, and try to give the industry a break.
Yeah, and this creates a real burden on regulatory compliance professionals because the game keeps changing. The rules of the game keep changing, and not just lawyers and consultants like you and us, but the regulatory compliance officers, they've got to be beside themselves with the unstable, uncertain environment that's created. Sometimes it's better to have, even if it's a more unfavorable environment, at least if you know what the rules of the game are, you can plan for that. But when the rules of the game are changing from every 4 years, it creates a nightmare, I would say, for a lot of people. And I'm certain in your legal practice, and you deal with many, many financial institutions, your practice, I'm certain that you're seeing people like pulling their hair out of wondering, well, how do I deal with this radically unstable, very rapidly changing environment?
Well, uncertainty is indeed the current state of the regulatory landscape. But again, our advice is stay the course, but enjoy the reprieve from the elimination of disparate impact theory used by the federal regulators during the current administration.
Yeah, that's great advice.
Yeah. Lori, it just seems like time is flying. This is session 2. Maybe we should come back for sessions 3 and 4 in the near future.
Lots to talk about, I'm sure.
And you know what, Lori? I think what's going to happen between now and the end of the year, here we are at the beginning of September, we're doing this recording. There could be a lot of changes and things will play themselves out. So maybe at the beginning of next year, we could have a follow-up session to see what's developed between the Trump administration and, of course, the differing states and how they respond to. I think our audience would be very, very interested in that. So if you don't mind, I might give you an invitation once again in another 6 months or so to come back and catch up on what's been happening.
I'd love to be a returning guest on your podcast, Len and Dean, and thank you again so much for having me.
Thank you for graciously appearing on our show. We're honored to have you. Dean, I'm going to sign off on my side. This is Len Suzio with Geodata Vision saying thank you for joining today's session. Dean, it's yours to say goodbye.
Yes. Well, thank you, Len. And yes, and thank you, Lori, for joining us today. And to our audience, please let us know of any podcasts or topics that you would like to hear in the future. Thank you for attending today's podcast with Lori Sommerfield.
Thanks for listening to the Compliance 911 Show. If you like the podcast, be sure to subscribe so you don't miss an episode. While you're at it, please give us a like and review to help others find the show. As always, links are in the show notes, and you can always find us online at compliance911show.com. Follow M&M Consulting and Geodata Vision on LinkedIn for all the latest news and information on compliance hot topics.